Kindly subscribe to YouTube channel and follow on Facebook page at Dr. Zabby's Talk Show.
àmọ́ tó yín yẹn lélẹ́yìí o so àti ibi tó wà so àwọn ti kún yìí àwọn ti písìsì ẹ̀ yìí so àwọn tó kún mọ́tò yín lélẹ́yìí o àwọn lójúkòó lẹ́yìn àwọn lélẹ́yìí.
mo kí gbogbo wa nílé lóko lẹ́yìn òdì mo kí wa pé a kú bójú ọjọ́ ṣeré èmi ọmọ yín olólùfẹ́ yín ààyè ọ̀pẹ yọ ṣe ọlọ́dọ̀ tí náà ní agbára lọ́wọ́ àṣẹ̀dá ààyè ọpẹ́ á máa yọ fún wa lórí wa lórí ọmọ lórí ìdáwọ́lé wa láàyè ọpẹ́ máa yọ fún èmi àti yín. Èwo ni mo ní ká jọ ṣe àgbéyẹ̀wò ẹ̀ lọ́jọ́ títí òní gẹ́gẹ́ bí àṣejọ máa ń ṣe quick one òun ni eléyìí. Ṣé o léèyàn nínú UK tàbí o léèyàn tó ń bọ̀ nínú UK tàbí o tiẹ̀ léèyàn tí ọkàn wọn tó ń dààmú pẹ̀lú gbogbo nǹkan tó ń ṣẹlẹ̀ nínú UK yìí lọ́wọ́lọ́wọ́ yìí. A dúpẹ́ lọ́dọ̀ àṣẹ̀dá. Sísà wa kan ìyá wa kan ó wà níkàlẹ̀ báyìí tí wọ́n ń fi ọ̀rọ̀ jómitóró ọ̀rọ̀ fún tó jẹ́ ìkan lára àwọn gbòógì immigration nínú ìlú UK yìí. Àìbámọ̀ bóyá o léèyàn ni o tó tọkàn ẹ̀ ń ru sídìí kan sídìí kejì nínú UK tá a wà yìí gẹ́gẹ́ bá ṣe mọ nǹkan tó ń ṣẹlẹ̀ lọ́wọ́lọ́wọ́ nínú UK. Àfi kí Ọlọ́run Elédùmarè kó jẹ́ kí èmi àti yín ká kéré oko délé. Gbogbo mo fẹ́ wa kí Elédùmarè kó bá wa fẹ́. Gbogbo èyí tá a fẹ́ kẹ́lẹ́dàá wa kó kọ̀ fún wa. Ẹ má jẹ́ kí n gbà wá lákòókò. Bẹ́ẹ̀ bá ṣe ń wò ó ẹ jẹ́ ká tẹ like ẹ̀yin náà ẹ appreciate iṣẹ́ wa. Bẹ́ẹ̀ ni iṣẹ́ ni iṣẹ́ ń jẹ́. Ẹ bá wa pín ẹ bá wa share kó lè dáa. Òun ni page wa yìí òun ló wà fún. Mo dẹ̀ mọ̀ pé lágbára lọ́wọ́ Elédùmarè mo ṣe ní ìwúre fún gbogbo wa wípé á dáa fún wa o ju bá a ṣe lérò lọ lágbára lọ́wọ́ àṣẹ̀dá. Ẹ má gbàgbé tó bá jẹ́ nígbà àkọ́kọ́ tẹ́yin ṣẹ̀ṣẹ̀ fẹ́ darapọ̀ mọ́ wa ọ̀tẹ̀ darapọ̀ mọ́ wa lórí ìkànnì yìí ẹ má gbàgbé láti bá wa subscribe so that anytime tá a bá ṣe program ẹ lè máa rí notification. Bẹ́ẹ̀ ni mo fẹ́ fi àkókò yìí sọ fún wa wípé àwọn program kọ̀ọ̀kan tí mo máa ń ṣe lórí ọ̀rọ̀ wípé ìtúsílẹ̀ ọkàn ìtúsílẹ̀ ọpọlọ tán ti kó àwọn ìran wa sí ní ọjọ́ tó ti pẹ́. Mo fi àkókò yìí sọ fún wa wípé orí Àjùlọ TV lẹ máa ti máa wò ó. Ibẹ̀ ni a máa gbé yẹn lọ lórí ọ̀rọ̀ ẹlẹ́sìndé ni o. Àjùlọ TV ẹ̀yin tí ẹ báyìí tí mọ Àjùlọ TV ẹ lọ type tó bá ti gbé wá fún yín ẹ subscribe sí so that anytime tí a bá upload fídíò síbẹ̀ ẹ lè máa jẹ́ ẹni àkọ́kọ́ láti máa rí. A máa kéde yẹn lórí ìkànnì yìí ní gbogbo ìgbà wípé gbogbo ọ̀rọ̀ ẹlẹ́sìndé ẹ jẹ́ ká máa gbé lọ sí Àjùlọ TV ká lè ṣe ní ọ̀tọ̀ọ̀tọ̀ ọlọ́tọ̀ lóhun ọ̀tọ̀. Bẹ́ẹ̀ ni kò ní sú wa kò ní rẹ̀ wá o àṣẹ ló máa give up. A dúpẹ́ lọ́wọ́ yín ẹ ṣé gan ni bẹ́ẹ̀ ṣe ń darapọ̀ mọ́ wa bẹ́ẹ̀ ṣe ń kí wa ipa kó ètò bẹ́ẹ̀ náà làwa náà kí yín pé a kú bójú ọjọ́ ṣeré. God bless you. One love. Bye for now. Ire o ire gbangba. Let's go there.
Most people think moving to the UK legally is impossible, but this is because they do not know. Today, you are going to get first-hand information that could change someone's life. Without wasting your time, can you please introduce yourself to the audience?
Hi, everyone. Once again, thank you very much for having me on this program. I'm Laurentia Kwijiraful, and I specialize in immigration law in the United Kingdom. I'm a qualified solicitor, so I hope what I'm going to do today is going to benefit a few people. Thank you very much for having me again.
Immigration a problem in the UK?
No.
Why did you say no? Because it's fundamental to our existence.
Oh, why'd you say that?
Because we need it. We don't have enough people being born in this country. We need immigrants. It's simple.
Why does the UK fear immigration?
We're told to.
By who?
The elites that own us. So the capitalists and the billionaires that are in charge that really own us and own our parties, mostly the Tories, but now Labour as well, they tell us to fear it because they need someone to blame for our problems when really they're the ones causing our problems.
Last 10 years, there's 6.2 million people on the waiting list for NHS and 2 million children in poverty in the UK. That allegedly, that is due to immigration. Do you have any thoughts on that?
I think it's not due to immigration. Immigration is the reason our NHS works. The thing that causes that is governments deliberately underfunding and sort of underutilising the NHS for what it could really be. It's nothing to do with immigrants coming in. It's to do with it being badly managed and badly funded.
Thank you, Laurentia, for joining us today. So we've got a list of questions from our audience. The first question that we have is that if someone who moved to the UK on a carer's visa and had children who were under 18 when they came to the UK, and their children haven't lived in the UK for 2.5 years, their children have now turned 18. They are now over 18. What are the chances of those children and how do they apply?
Now, the Home Office have taken into consideration this group of people, and the immigration rules actually provide for them. So they can still make applications for those children, even though they are now 18 years old, provided the children came into the country as their dependent and they are not leading an independent life. So for instance, the child entered the country with the main applicant or the sponsor of the application, maybe when they were 16 years old. Now they are 19 years old. Now the fact that they are 19 years old does not preclude them, okay, from remaining as dependents on the main person's application. What they have to prove is that the person is still part of the household and that child is not leading an independent life. They may be in school, but where do they come during their term times? Do they come home? So once they are still living with their parents, once they form part of the family unit, they can still put them on as dependent.
So even if the child who is now an adult and they are 19, 20, as long as they still live with their parents, they can join their parents' application. Is that correct?
Yes, they can. And that it's important to realize that they must have had leave to remain as a dependent of their parents before they turned 18.
What if they don't live with their parents? Does that affect?
Some children don't live with parents because they are in school. Okay.
Yes.
So if you are in school, then they have to show why you are not living with your parents. So for instance, term time, you are in school, but during vacation, you come home. So all your addresses, everything, your proof of address, everything is still with your family. Then you should be all right.
Good. Guys, we've got an experienced immigration lawyer today who will be able to answer all your questions. We've got questions here from the audience. If you have any question that you want to ask Laurentia, please put the question in the question section. It's not every day you have an experienced immigration lawyer who is prepared to answer your question. Let's go to the second question. So if you have a couple who moved to the United Kingdom, right? Say after 18 months, initially, the man was the woman's dependent. After 18 months of living in the UK, the man found a better job that offers him sponsorship. Would he be able to apply for indefinite leave to remain, having lived in the UK for 5 years? For 2.5 years, he was his wife's dependent. And for 2.5 years later, he is the main applicant. Would he be able to apply for indefinite leave to remain?
Okay, now with this one, it comes under appendix skilled worker. It's important that people realize that when it comes to appendix skilled worker, when you're applying for indefinite leave to remain under appendix skilled worker, you cannot include time spent as a dependent. Okay, so they cannot do that. What they can do is either the man spends the 2.5 years, extends the visa again for another 2.5 years, or a combination of, so let's say now they've given the person 3 years, for instance. If they give the person 3 years and then later on they give the person 2 years, or they give the person a straight 5 years, what the man has to do is the man has to spend time as a main skilled worker for that 5 years. Then he can now qualify to apply for indefinite leave to remain. He cannot combine a period spent as a dependent and a period spent as a skilled worker. When they are applying for indefinite leave to remain, they cannot.
Good. So just to be clear, so that means that for the man to be able to apply for indefinite leave to remain, he will then have to be on his visa for 5 years. That's altogether will be 7.5 years. 2.5 years spent as his wife dependent doesn't count.
Yes.
Okay, that is interesting. Thank you so much, Laurencia. So the next question we have is, if someone is on a post-study visa and want to apply for another student visa, and they have more than 28 days on the current visa, will they be able to apply for extension while in the UK, or would they have to go outside the country to apply?
Now, the person has to be very tactful in this particular situation, because paragraph ST 43 of Appendix Student makes it very clear that when you're making an application in country, okay, you must be able to, like, the course that you are going to study, it must not start more than 28 days. So from the date your visa expires. So let me give an example. If, let's say, your visa is expiring on the 31st of August 2025, you make your application, the course start date should not be beyond 28th of September. So in this particular case, what the person should do is the person should speak to the university that they want to go to school with, explain to them their circumstances, okay, and the school should be able to issue the CAS letter stating that, making sure that the course start date does not start more than 28 days from the last day of the person's visa, from the day that the person's visa expires. So if the school is not ready to do that, the best thing is the person should leave the country and make the application and come back.
So the person have to ask the school for...
Yeah. Okay. Speak to the school. Some schools are very kind, okay, they will do that, but it depends on when the courses start as well. So if the school can't do anything about it, of course you can't, but you may have to look for a course that actually falls within that 28-day period. The reason being that it's part of the validity requirement. So for the application to be received as valid, you must satisfy that requirement. So if you don't satisfy that requirement, they cannot accept the application as being valid. It's a risky thing to do. So it's imperative that they comply with that particular paragraph ST 4.3 of the immigration rules. Yes.
Okay. So the next question we have is, if someone came in as a student with a dependent, she is the main applicant and later got divorced. She now has a COS, which was granted to her. Would she be able to bring her dependent? I think this question applies to even people that came on the carers visa and couples, and they had issues in the relationship and they get divorced. Would one of the couple be able to bring their dependent from outside the UK, given that there is now change in the law?
Okay, now I'm assuming, okay, based on what you said, that a person's COS was issued before 4th of April 2024. Now, if that is the case, then of course the Home Office made provision for transitional provisions. Now, the transitional provisions caters for people in that circumstance. What it says is, if your COS was issued before the new changes, you can still sponsor people. Oh. So with this particular person, once the COS was issued they actually, hers is in 2023, so he was way in before the changes. You can still continue to sponsor your dependent, your spouses, your children, provided you satisfy the other eligible requirements. If you are able to show that you satisfy the other eligible requirements, you can sponsor your family members to come to the UK. The key thing to note is, when was the COS issued? Okay, so if the cutoff date was the 4th of April 2024, So you've got to bear that in mind. If it was before that, you are fine. If it was after that, then of course, unless you formed part of a family unit, okay, you were on a visa that recognized you people as a family unit in the country, then of course you can't do much about it. But if you were here as a family unit, that's when you apply for Home Office to exercise discretion on your behalf. But with that particular question, insofar as that COS was issued before the 4th of April 2024, and the person had that leave to remain by that time, then they are fine. They can still sponsor family members, yes.
Does that also apply for students who came into the country before students were stopped from bringing their dependents? Would they be able to bring their dependent?
Now, with the student rules, that one is different from the COS, the care worker visas. Okay, so what I always tell people is go back and check the transitional provisions. Okay, but currently, in relation to this particular one, there were specific transitional provisions that was made for the carers, so they are catered for.
So it sounds like what you're saying is that the carers will still be able to bring their dependent. For students, they may not be able to bring their dependents. Is that what you?
For students, you may not be able to bring, because when they stopped it, I think at the beginning of the year at the beginning of last year, when they stopped it, what they wanted, they had, when the Home Office bring in these rules and everything, they are trying to prevent people from coming into the country. So you've got to always check the transitional provisions. Okay, does it cover you? Does it not cover you? Very, very important.
Okay. So I think you've answered two questions. Yeah. So can a parent who have lived in the UK as an undocumented person, they have a child, that child came with them, they have all lived together for more than 7 years. Mm-hmm. Can the parents use the child to apply for leave to remain in the country on the basis that the child has lived with them in the UK for more than 7 years?
Now, we don't condone overstaying, but we do also know that sometimes people can become overstayers due to circumstances beyond their control. Now, if this should happen to you, okay, what you can do is, provided you can show that the child has lived in this country continuously for 7 years, that a child in that particular situation is deemed to be a qualified child. Now, those children, unless it is unreasonable, okay, you cannot expect them to leave the country. So currently, if you have a child who has lived in this country continuously for 7 years, and you can prove that it is unreasonable for them to leave the country, then of course they satisfy the private life grounds. So they can be given either 2.5 years or indefinite leave to remain, depending on how you make the application. Now, when that happens, the parents who are here can make applications under Appendix FM on the parent route. Now, Appendix FM, when it comes to the parent route, there are certain things that you have to satisfy. Now, of course, they are overstayers, so they will not be able to satisfy the immigration status requirements. That would mean something called Appendix EX1 has to be applied in their case. Now, in relation to a child, Appendix EX1 states that if a parent can show that they are in a genuine and subsistent parental relationship with a child, then they can be given 2.5 years and they can remain here as the primary carers of the children. So yes, they can do the application, provided they can show that that child has lived in this country continuously for 7 years.
Thank you so much, Laurentia. As you heard from Laurentia, if a child has lived in the UK with their parents who are undocumented, as long as the child has lived in the UK continuously for more than 7 years, the parents can use the child to apply to remain. That doesn't mean we're encouraging people to live in the UK legally, but that is the pathway that is open to parents. Thank you so much, Laurentia. If you've seen any value in this content,
kindly subscribe to YouTube channel and follow on Facebook page at Dr. Zabby's Talk Show.
Don't forget to give it a like to support what we're trying to do and share. I will read all the questions. We've got questions from Trendy Topic. I'll read all the questions, but let me go through the questions that have been sent to us. Lawrence said there have been a lot in the news lately about immigration and what changed to indefinite leave to remain, and carers who came in, who are approaching 5 years stay in January next year. whether they will be able to apply for indefinite leave to remain. Can you please update our audience on where we are, please?
Now, the rules, I always tell people that your starting point should be the immigration rules. Now, currently, most people have access to the internet, okay? And it's important that I tell you, you can find the immigration rules online. You just have to type UK immigration rules or Immigration Rules HC 395 as amended, okay? It will bring you all the immigration rules, everything that you need to know about the UK immigration rules. Now, if you don't find anything in there, that means it is not the law. Now, I do get the point that the Home Secretary, the new one, during the Labour conference, made certain assertions. She made some statements showing that this is her intent, or that is the government's intent. This is what they want to do in future, but that has not become law yet. So as we sit here today, if you are eligible for indefinite leave to remain, if you can show that you've been in this country as a skilled worker with a combination of other immigration routes, okay, as stated in Appendix Skilled Worker, then you can make an application for indefinite leave to remain, provided you satisfy the other rules. Now, the Home Secretary, what she's anticipating currently is that they are going to tighten the rules in relation to getting indefinite leave to remain. But they've also indicated that it will not be it will not be applied retrospectively. So that basically means that those who already could apply for certain leave to remain will not be affected by it. It will be the new people who are making new applications. And I think it's a good thing for them to indicate that that's what they intend to do. But as to whether they will do it or not, we are still not clear. Now, what they are trying to say is, before someone applies for indefinite leave to remain, they are going to increase the level of, it's interesting how they say certain things, like the English language. You have to speak it to a very high standard. You must show that you are volunteering. You must show that you've contributed to the economy. You must have a clean criminal record. You must not, benefits and everything. It's important that you're not claiming those benefits. They will consider all of that in looking at the time that you can spend in getting indefinite leave to remain. But all these ones are statements of intent. It has not become law currently. So yes, they may do it in future, but they haven't done it currently. So as we speak today, the rules still remains. It hasn't changed.
Thank you so much, Laurencia. I just want to quickly go back to the two questions that you've already answered before, because something that just came to my mind. So if you have a couple, they came to the UK before the changes in 2023. They came on a carer's visa, right? When they came, both couples, they are now divorced, yeah? The man decides to remarry, and he remarries, and his wife is outside the country. Would the man or the woman who have now remarried be able to bring their dependent to the UK, knowing full well that carers are not allowed to bring their dependent, but he came before the change was introduced?
Okay, the key here is who was the main carer. Okay, we will not consider the dependent because the dependents cannot. Now, the question is, who was the main carer? So the main carer whose visa was issued or who got the COS before the rule changes in April 2024 is the one who can bring the dependent, not the dependent. Yeah. Okay, so the main, should I give a scenario?
Yes, please.
So if, let's say, I'm originally from Ghana, so I'll use a Ghanaian name. So let's say Kofi is the main applicant as a carer, comes into the country with Ama, who is a dependent, his wife, okay? They all enter the country, let's say January 2024. So the rules hadn't been changed at the time yet. And Kofi was working and doing everything as normal. Ama was also as a dependent, going about her business. But then they divorced along the line, okay? Now, your question is, can any of them bring a dependent? Now, if Ama, for instance, who was a dependent, okay, got a new COS in her own right before the new changes, she can. But if she did not, and maybe she got a COS after the changes, she cannot. However, Kofi, who was the main applicant, can bring dependent in country or outside country.
Thank you so much. The next one I want to go back to is someone who came on the carer's visa. The person has worked with an employer for over 2 years. For instance, they came as a social worker, they came as a carer. They then found another employer with better condition and switched to another employer, but in the same caring profession. Can they apply for indefinite leave to remain, having worked in the UK for 5 years in the care sector with 2 employers?
Yes, they can.
Okay.
They can combine that all those periods. Yes, they can, because it's a skilled worker and a skilled worker, so it's provided for in appendix skilled worker. They can.
Thank you very much. So let's go to the next question, guys. Don't forget to give this video a like and share. Put your questions. They will come to Laurencia soon. Laurencia, so this question is about no recourse to public fund. If you have somebody who is on no recourse to public fund, when they apply for renewal, would having no recourse to public fund affect their chances of their visa being granted?
No, not necessarily. Now, let me give an example. If, let's say, you were granted leave to remain on 2.5 years, as maybe the parents of a qualified child, a British citizen, or someone who's been here for 7 years, and after you were granted a 2.5 years, you realize that, look, you are in need, you are struggling, you can't make ends meet. You apply for change of circumstances. So they now remove that restriction of your leave to remain and now allow you to have recourse to public funds. What you do is, when you are making your new application, if you want to continue on that particular route or route, you just have to apply for a fee waiver before your visa expires if you cannot afford the fees again. And then what you do is, they will give you, if they assess your circumstance and they realize that you don't have the means to pay the fees, they now give you a code that will enable you to make a new application. Now, provided you satisfy the other requirements of the rules, they will still grant you your 2.5 years.
Okay, and as you were telling me before, it will be better every time they are renewing, it will be better for them to apply for fee waiver.
Yes, every time you are renewing, if you want to continue on the no recourse to public funds one that they've given to you, every time you are renewing, it's best to apply for the fee waiver. However, it's important to note that the Home Office will consider your financial circumstances at every stage in the application. So if, let's say, you do it 4 times, okay, because you're on the 10-year route to settlement, at every time, every fee waiver application, they will consider your financial circumstance. They won't look at your previous history. No, they won't. They will consider your circumstances at the time of making the application to decide whether or not to grant you the fee waiver or not, or to remove that restriction from your leave to remain.
Okay, that's good. Thank you so much, Laurencia. So we've got a question here about indefinite leave to remain. I think Stacy has a question, but Stacy, can you please reframe your question about benefit, because it's not very clear. So the question here is about, for someone who has indefinite leave to remain and work visa, how long can they live outside the country before their visa is revoked?
Okay, now with this one, it would be best to do it in 2 segments. So we'll deal with the indefinite leave to remain first. Let me write this one down. We'll deal with the indefinite leave to remain first, and then the work visa first, okay? So you said, how long can they live in the country before it is revoked, right?
No. How long can they, say for instance, I have indefinite leave to remain. I visit Ghana or Zimbabwe, my country. And how long can I stay there before my indefinite leave to remain is invalidated?
Okay. Now, with the indefinite leave to remain, normally, if you look at the rules, okay, if you got the indefinite leave to remain under the immigration rules like Appendix FM, you shouldn't leave the country. You shouldn't stay outside the country for more than 2 years. Now, if you stay outside the country for more than 2 years, the leave lapses, okay, unless you want to come back as a returning resident. So you have to now fill an application to come back as a returning resident, and you have to satisfy that some requirements. Now, if you made the application under the EU settlement scheme and you were granted settled status, with those people, depending on the country, if it's any other country but Switzerland, okay, the Swiss nationals, it's 5 years. So with those examples, if that someone comes from Portugal or let's say Holland, for instance, okay, or Netherlands, sorry, those people, if they stay out of the country for 5 years, their leave lapses, the indefinite leave to remain will lapse by operation of law. Now, with those who are from the Swiss nationals, it's 4 years. So with the indefinite leave to remain, everyone, and it applies differently to different people. So it's either 2 years, 5 years, or 4 years. But depending on your circumstances, if you want to come back, what you do is you apply as a returning resident, or you make a new application under the EU settlement scheme. But what we always advise people is, why stay outside for 5 years? All you do is, if let's say if you're an European Union national who have settled status, you go for a year, come back for 6 months, go back. Just make sure that you don't have that continuous 5 years outside the country. Now, if the 2 years is applicable to you, why stay out of the country for 2 years and then you have to make a new application to come? All you do is stay outside for maybe 6 months, come back for a month, go back 6 months, come back for a month. So just make sure that there's a break in that qualified period that they refer to. Then you should be okay. Now, that is for those with indefinite leave to remain. Now, for those with skilled worker visa, the rules does not specifically state the number of days that you can spend outside the country, provided if you just want to renew your visas in country. However, you have to bear in mind that you are in this country mainly because you are supposed to work for an employer. Now, so if you spend prolonged periods out of the country, the question is, are you working for that employer? Now, the employers have got certain duties, okay, to make sure that they notify the Home Office. For instance, if you don't come to work for like 10 days, they have to notify the Home Office. If it's unpaid leave absences for more than 4 weeks, they have to notify the Home Office. Now, so if they notify them and they think that you are not in a genuine employment, then your visa can be curtailed. So what we advise people in that situation is, as much as possible, if you really want to work, stay here, work. Of course, you can go on holidays. You can go on with the permission of your employer for short periods and come back. But for the avoidance of doubt, and just to make sure that you don't find yourself in trouble, don't stay outside the country for prolonged periods of time. Now, when they are applying, some people may say, oh, my employer may give me the opportunity, but it will be strange for an employer to give you an opportunity to spend prolonged periods of time out of the country. The question is, are you really working for them? Now, under certain circumstances, that may happen, but whatever it is, even if you stay out of the country for a prolonged period of time, for instance, when you're applying for your indefinite leave to remain, you have to satisfy appendix, continuous residence. Now, that appendix, it comes to their notice that you spent around 180 days in a 12-month given period, that could affect your indefinite leave to remain as well. So I always tell people, make up your mind. What do you want to do? Do you want to stay here, or do you want to stay out of the country? And then based on that, make your decisions. But if you apply for that skilled worker visa and you think you want to eventually apply for indefinite leave to remain, then come, stay, finish your 5 years, and then you can do whatever you want.
Thank you so much, Laurencia. Laurencia's contact number. Please do not contact me asking me for Laurencia's number. Laurencia's contact number is in the description section of the video, and I'm going to give you her office number. It is 0182 733 7791. I repeat, 0182 733 7791. If you've seen any value in this content, don't forget to give it a like and share. Laurencia, the question about how long those on care workers visa can live in the country before they apply for indefinite leave to remain, you said it's 5 years. Is that definitely 5 years?
Now, it depends. Now, with the skilled worker visa, it depends on the skilled worker visa. Some can do it within 3 years. It depends. But our focus currently is on the care workers. So with the care workers, it has to be 5 years. But the other highly talented people, okay, those ones, they have different different requirements. But for the carers, it has to be 5 years.
Thank you so much. You heard today that if you have a child and the parents are overstayer, if the child has lived in the UK for 7 years, the parents can use the child to apply for leave to remain and then use that to apply for themselves and stay in the country. If you know anyone who falls in this category that will benefit, share this video with them so that they can use that opportunity to apply to remain in the country. Laurencia, the last question we have before we start reading the questions from the audience is about somebody who is in the country who is an overstayer. Can they marry a British or EU citizen and apply whilst they are in the country?
Now, that's an interesting question. Okay. I always like reiterating that we don't condone overstaying, but of course, under certain circumstances, people can overstay, and it will be because of something beyond their control. However, if you find yourself as an overstayer and you happen to genuinely fall in love, okay, with a British citizen or an European Union national, now, depending on how you get married or where you get married, you can obviously make an application as a partner of the person, depending on the circumstances. Now, so I'll give an example. If, let's say, you have overstayed, but you meet someone you genuinely are in love with and you want to get married to the person is a British citizen, okay? Now, you can decide if you come from a country where, now, when it comes to the, let me make a point on this one. When it comes to the validity of a marriage, okay, in relation to international law, it is the laws of the country where the marriage was celebrated that governs the validity of a marriage. So, for instance, someone from Ghana, if you take the Ghana proxy marriage, which is the customary marriage, which is a traditional engagement, or how people call it, where the families meet, they dress up, they have all these big parties and those things. So the customary marriage, it is recognized as a marriage in Ghana, and it can be done by proxy. So for instance, if the person who has overstayed comes from Ghana, for instance, okay, then what they can do now, it's important. I mentioned Ghana because other countries like Nigeria, proxy marriages from Nigeria are not recognized. So you cannot use the proxy marriage from Nigeria. The two parties has to be in the country for that customary marriage for it to be recognized by Nigeria. But in Ghana, they don't have to be, they are not required. So that's why I use Ghana specifically. So if, let's say, they do the Ghana customary marriage, okay, it's recognized in law in Ghana, and then they bring it over here. Now, the person who wants to do the application can do the application provided there's a minor child involved. And this relates to human rights applications, not skilled worker applications. So the applications can only be done under Appendix FM. So if you have overstayed in this country and want to do a marriage application, it always has to come under the human rights, not the other rules. The other rules, you have to, like Appendix skilled worker, you have to leave the country, make the application and come, provided you satisfy the rules at the time. But with this one, if the person is a British citizen, you have to also ensure, yes, you can do the marriage and bring it in, but then you have to ensure that there's a minor child involved. Now, if there's no minor child involved, or if you cannot show that there are insurmountable obstacles that will prevent the two of you from relocating to Ghana or outside the country or wherever you want to go to, then the application will not be successful. So they can get married from Ghana, for instance, use the marriage certificate, provided they can show that Appendix EX1 is applicable. Now, if there's no child involved, they have to leave the country, make the application, and come back. If there's a child involved as well, what they can also do is they can get married in United Kingdom here. However, if you don't have leave to remain and you want to marry in the UK, you have to give a notice to the registrar. The registrar, under the rules, have to notify the Home Office that you want to get married. The Home Office have got 70 days to look into the marriage, whether it is genuine or not. Now, if they give you the approval, of course, you can get married here, and then you can use the marriage certificate, provided there's a minor child involved. But if there's no minor child involved, there's no need in doing the marriage and everything here. It's always best to leave the country, get married there, and then come back into the country.
Thank you so much. We've got some questions I'm going to read out. Trending news, can you put your questions again? Because we've got so many questions that your question has just gone up. I think you have a...
Kindly subscribe to YouTube channel and follow on Facebook page at Dr. Zabby's Talk Show.